All right. Well, I do believe I am live right now. So thank you everyone for joining me. If you can see me, it means that I've done this correctly and I'm live. My name is Lior Samfiru. I'm the employment lawyer. Hopefully you know me by now. You've seen me before and you know what I'm here to do. Well, I'll tell you anyway. I'm here to talk about employment law. I'm here to talk about employment law rights and to answer your questions and to tell you what you need to know about rights. If you want to know about something, if you have a question, a problem, an issue, this is the time, this is the place to ask. I'm one of the founding partners of Samfiru Tumarkin LLP. We're the largest employee side firm in Canada. And I spend most of my time resolving workplace problems and answering questions and hopefully educating and informing people about the law. What I want you to all remember is that employment laws in Canada are actually very, very good, some of the best in the world. But employment laws can't help you unless you know what they are. You don't get rights unless you know what your rights are. So that's what the purpose of this session is, to advise you on your rights, to inform you on those rights. So it starts by asking a question. Whether you're on YouTube or on Facebook, you have the ability to write your question in, press enter, I'll see it, I'll read it, answer it, and you can walk away with the knowledge that you need to have. Now, let me give you some other contact information, okay? If you want to connect with me off social media, if you want to speak with me off air, email exchange or phone number, all you do is you go to employmentlawyer.ca. Again, employmentlawyer.ca. You see that address below me, and you'll see the contact information is there, your phone number, email addresses, forms, everything you need for myself and my team is right there. So don't be bashful. We may not get to your question, or you may want to ask follow-up questions after today's session. Just go to employmentlawyer.ca. Again, those joining us, I'm the employment lawyer, Lior Samfiru. I'm answering questions here live. If you have time, ask your question. I'm going to start answering some questions right now, but please don't take your time, because if you do, we're not going to be able to get to it. Okay, on YouTube, first question is from No to Trudeau. How long can you be placed on an unpaid leave for not being vaccinated? I'm not unionized. Well, the answer is that you cannot be placed on a leave legally, meaning if you're put on an unpaid leave, you have the right to treat that as a termination now on day one. So you don't have to wait to day 5 or day 30. You can choose to say, by putting me on a leave of absence, employer, it's as if you've terminated my employment and now you have to pay me severance. So that severance can be as much as 24 months. So it's not a question of how long. It's a question of, did they have the right to do that to begin with? And in most cases, unless there's a government mandate that applies to you, and there probably isn't, then no, they did not have a right to put you on a leave. You can treat that leave as a termination. So if that's what you want to do, it starts by giving us a call off air so we can connect and we can get that process started. Again, to connect with me, employmentlawyer.ca. Good question. Thank you. Next question today on Facebook from Heather. Company introduced new vaccine policy in October 2021, facing being put on an unpaid leave for not providing my proof of vaccination. What are my rights? Well, that's exactly what I just answered. You have the right to treat that as a termination. So you have to make the choice, first of all. What is better for you? Are you better off keeping your job and getting the vaccine? Or are you better off losing your job, getting severance, and not getting the vaccine? That obviously is a personal choice, but there's no way to physically stop your employer from letting you go or putting you on a leave. The only thing you can do is, if that happens, ensure that you get compensation. And to get that compensation, you reach out to us, again, employmentlawyer.ca. So Heather, those are your rights, but it starts with you deciding, are you willing to lose your job? I can't answer that for you. That's your decision. Next question on Facebook from Kim. I was terminated with cause due to refusing the jab. My termination letter reads they will take me back if I got vaccinated. That's not cause, Kim. Being let go because you're not vaccinated is not cause, meaning the law looks at it as a without cause termination. If it's a without cause termination, they owe you severance. So you have two options. You do nothing and you walk away, or you get your severance because it's not cause. We need to get involved. We've been doing this now since August. hundreds of people across Canada that we represent in exactly these cases, wrongful dismissal cases because of the vaccine. So again, contact me off-air, employmentlawyer.ca. Let's get to work. It's not cause for you or anyone else. If you are let go, the law is going to consider that a without cause termination. Your own compensation. Very good questions today. Let's see. Next question from Anne Marie on Facebook. I'm a sales representative. My current base is at 90,000. My employer is reducing the base to 75,000, but increasing my commission from 1 to 2%. Yet there is no guarantee for extra revenue. Is this legal? So a change like that, Anne-Marie, results in a constructive dismissal. So as I said before, there's two options here. You can accept this change and continue working. Obviously, that's your right. The second option you have is you can treat this change as a constructive dismissal, as a termination, and require them to pay you severance. So even though it's not legal, there's no way to stop them. They're making this change. Whether or not they're increasing the commission is irrelevant. If they're reducing your base from 90 to 75, that's a constructive dismissal. That's a big reduction, probably around 18, 20%. And you can treat that as a constructive dismissal. Now, Anne-Marie, for you and for anyone else, if you want to know how much severance you're owed, so Anne-Marie, for example, I told you they owe you severance. I've said that before. If you want to find out how much severance, here's what you do. All you do, you see the address below me, is you go to pocketemploymentlawyer.ca. Again, pocketemploymentlawyer.ca. We have our severance calculator tool there. It allows you to find out in seconds how much severance you are owed. Maybe it's 6 months, maybe it's 24 months, maybe it's somewhere in between. It's easy, it's free, it's anonymous, it takes seconds, very, very easy to use. So if you want to know, Anne-Marie, all the others, when we're talking about termination or constructive dismissal, how much you're owed. Maybe you just lost your job. Maybe you're worried about losing your job. Just go to pocketemploymentlawyer.ca and you'll be able to get your calculation of your severance. All right. From JC 2004. If your complaint of representation from a union is not approved by the requesting authority, can the decision be appealed? If so, which authority? So you can, if you're asking the labor board to force your union to represent you, and the labor board dismisses it, you can get judicial review to the court, depending on your province. I don't know what province, but it would be the name of the court would be the one in your province. The reality is the chances of succeeding is very, very, very small. I wouldn't do that. I would not do that, not because you can't, because the chances of succeeding in a unionized situation is very small. Okay, next question. Let's see, from the Dreamer on YouTube. Can an employee still receive severance pay if both the employer and a third-party client has a vaccine mandate for you to work and are on unpaid leave? So here's what I mean by that. If you're working not for your employer physically, but you're working for a third party on their premises, and that third party is telling your employer, for you to have the Dreamer work here, you need to have them vaccinated, then at that point your employer doesn't have a choice. Whether they want you to be vaccinated or not, they don't have a choice. So then, if you don't get the vaccine, they can let you go without any compensation or put you on a leave without compensation. So if there's a third party that obligates your employer, then that relieves your employer from severance liability. If it's your employer making the decision, then that's very different. So let's see. Oh gosh, I've just lost all my questions. Every single question I had, I've lost. I had many questions, and I've lost them all. So I'm not sure if anyone there is able to help me, Steph or Danielle, and see if I can get back my questions. Okay, let me continue talking about a few things, but right now, if you posted a question, maybe you repost it. I'm not even sure if I can see them because it looks like I've lost every question that I had. So we're talking about vaccines, and we're now in a situation where the government, some governments in Ontario and in Alberta, BC, I think may do that as well, are getting rid of some of the vaccine passports that they had. that actually may help you in a case where you've been either let go or on an unpaid leave, because the government is saying it's actually not necessary to be vaccinated in order to stop the spread. It's a good thing to be vaccinated, but it's not necessary, if you know what I mean. So whatever the governments are doing right now actually helps you if you're in a dispute with your employer with respect to your vaccines. Let's see. Hopefully I can get some questions. Robin on Facebook. I am fired with cause for vaccine mandates. My employer is denying severance. I'm suing them. However, they are still saying they owe nothing in their defense. What could happen next? Well, you need to speak to your lawyer about that. If you're in a legal dispute, I'm not going to advise you. Your lawyer needs to advise you on what happens in the process. But certainly, you didn't expect that in their defense they'll say, "Oh my gosh, we screwed up. Here's severance." Obviously, they're going to deny it, but that's why there's a legal process. But to tell you what happens next, you need to speak with your lawyer about that. Again, I don't know if anyone can even see me right now. I'm not seeing any questions. Everything's kind of frozen here on my end. So let's see. You know what? I am going to disconnect and reconnect and see if that works. All right, maybe can someone let me know if I'm live now? I'm not sure if I'm live. Okay, so next question is from Akib. I injured myself at work, 2 years of light duties. Doctor said the injury is permanent and now I can't do my pre-injury job. WSIB and the employer had a meeting. They let me go because of no work. I'm unionized. So, Akib, you have to talk to your union. The only one that can advise you is your union. And by the way, everything we talk about on these sessions only applies to non-union employees. Okay, only applies. So, Akib, if you're experiencing a workplace issue, the only one that can advise you or help you is the union. So you have to talk to the union, and if the union won't help you, unfortunately, you don't have many options. That is the problem with being unionized. Next question from Jordan on Facebook. When on stress leave, how often can an employer request verification from a doctor? Got a friend who might go on stress leave. So generally speaking, you need to have a doctor's note to go on stress leave. And it's up to the doctor to say when there will be an update next. So the employer doesn't get to say every week, every month. But if it's been a long time and there's no update, yeah, the employer can request some information. So it's a question of what is reasonable. But generally speaking, a good doctor will say, okay, this person needs to go on a leave. We'll have an update in 3 weeks, for example. Then there's an update. But if the doctor doesn't say anything and it's been a long time, yeah, the employer can certainly ask at that point for an update. For those joining us, my name is Lior Samfiru. I'm the employment lawyer. I'm answering questions. If you asked the question before and I didn't answer it, see if you can copy it and answer it again. I lost the questions that were there. I had a bunch of questions on the screen, and through the magic of the internet, they were lost. So see if you can ask them again. I'm going to continue answering. Next question is from Tanis on Facebook. My husband was suspended for not being vaccinated, but they are now asking if he wants to come back since the mandates are lifted. Can he still sue for severance? Yes, he can. Okay, absolutely. If that's what he wants to do, have him reach out to my office as soon as possible. He can. So, but before he responds, before he says yes or no, let's talk about that. Let's assess how much he's owed. Let's assess the nature of his job, and we can tell him exactly what makes sense for him. So, Tanis, to connect with me, easy, employmentlawyer.ca. You see that address below, employmentlawyer.ca. Phone numbers are there, email addresses are all there. So have him connect with me before he responds to his employer. From Elaine on Facebook. My employer extended my unpaid leave. Anyway, my concern is this: if I'm called back, I feel that my credibility is tarnished. But prior to going on an unpaid leave, I was vilified and bullied for my choice not to be vaccinated. So do I have any recourse if called back, but choose not to because of the potential hostile work environment? So this is exactly, Elaine, what I was saying to Tanis before. You can still treat this leave as a termination, regardless of being called back to work. It was a termination when the leave started. So if you were laid off on a Monday, or if you were put on a leave on a Monday, that Monday it was a termination. So you have a decision to make. Do you pursue this as a termination and get severance, or do you go back? But you don't have to wait to be called back. You can choose to treat this as a termination now, today. If that's what you want to do, Elaine, let's talk. Connect with me off air, but I wouldn't wait on this. Ideally, we do this before you actually get called called back to work. That would be even better. So to connect with me, employmentlawyer.ca. Again, employmentlawyer.ca. Next question from Facebook. It's Brandon's question. My employer had a vaccine policy and put me on an unpaid suspension for non-compliance. Recently, the Alberta government announced they will be getting rid of the vaccine pass. My employer is now emailing me asking if I will come back as they are reviewing their vaccine policy. So, Brandon, I'm not sure what the question is. You didn't ask a question. So maybe ask a question. I'll be happy to answer it. Next question is from Lena on YouTube. If an employee was hired through an agency, and if an employee that was hired through an agency had a workplace injury, and the workplace was at fault for violating health and safety rules, is the employee allowed to sue, or can they not sue due to WSIB? No, you would not be able to sue. There would be WSIB coverage, but you would not be able to sue the at-fault company, the at-fault employer. That's just how the laws are with respect to workplace injuries. So Brandon is asking the question, would I be able to go for back pay and job reinstatement? Well, I mean, you don't need to go for reinstatement because they're offering you your job back. But in terms of back pay, yes, you can. But more specifically, you really would have to make a decision. And that decision is, do you go back or do you pursue compensation? You really won't be able to get both. So if you want to go back to work, you can go back to work, but then you're going to forgo severance and any other amounts. If you don't want to go back to work, then you can get compensated. But you have to make the decision between one of those two things. Okay? And then if you want to go back, you can. If you choose not to, then we need to speak and we need to put a process in place to get you that compensation. Okay? To connect with me, employmentlawyer.ca. Again, employmentlawyer.ca. So let's see. Next question. By the way, joining us, ask questions. We still have some time, but not a lot. So please ask your questions so that when we're done here, you've had that question answered, okay? My name is Lior Samfiru. As I said, I'm the employment lawyer, one of the founding partners of Samfiru Tumarkin LLP. We operate in Ontario, in BC, and in Alberta. And why am I here? It's obvious, right? Answering your questions. So ask them, I will answer. JC2004 asks, if you work for a company who guaranteed you hours, but the third party doesn't have work for you, does your employer have to pay? Well, if you have a guaranteed amount of hours from your employer, if there's an agreement, a written agreement or something where you can show that there was a guarantee, yeah, of course they have to pay you. Absolutely they do. But you have to show that there was a guarantee. If your employer guaranteed you a certain number of hours, in other words, a certain amount of compensation, and now they don't pay it, well, no, too bad. They have to pay it. So the question is, how do you establish that guarantee? If it's just a verbal thing, it's tough. You need something in writing, ideally. Next question from YouTube from Zuzuna. The government of Alberta lifted the mandates. Doesn't the employer supposed to remove their mandatory vaccine policy due to the government announcement? No. So the government announcement has nothing to do with employers. Employers can make their own policies, right? The government is not telling employers you can't do something. But remember, those policies were not necessarily something that they were allowed to do in any event, even before the government reviewed or changed their own policies. So if you're put on a leave You can't stop that. If your government your employer has a policy that says you have to be vaccinated, you can't stop that. But what you can do is get compensated if you lose your job or if you're put on an unpaid leave. So the law cannot stop your employer from doing something. There's no employment law police that can go into the workplace and arrest your employer if they do something. What you can do and what the law does allow is for you to get compensated if your employer does something that they're not supposed to do. Heather asks on Facebook, let me just get that. Where are we? Here we go. Do you still get company benefits when you are let go with severance? Absolutely. So the company has to continue your benefits for the severance period. So let's say you're owed 15 months severance as an example. So you have to get paid for 15 months and your benefits have to be continued for 15 months. Sometimes we can, instead of benefits, we negotiate an additional amount on account of benefits. But yes, generally, the employer has to continue your benefits for the same period that you get severance. From Rafe, I'm sorry if I mispronounce, on Facebook. I'm an internet marketer and I was extremely impressed about the marketing strategy. Really, this is the time to ask that, Rafe? Seriously. Next question on Facebook from Lauren. Does the vax not stopping transmission do anything for delegitimizing of work mandates? Yes, it does suggest that there's really no good necessary reason for it. But as I said, we had that, we knew that even before the government did that. So it helps, but it doesn't change the analysis. Absolutely. So let's see. Next question is from Pauline on Facebook. I've been on disability. My employer has said I am now going to be removed from payroll as I don't have a return date. So they're firing me. What can I do? Well, no, that doesn't mean they're firing you. I'm not sure exactly what you mean by removed from payroll. At the end of the day, your employer doesn't have to pay you while you're off, right? And unless they've told you that they're firing you, that doesn't mean anything. This may just be an accounting thing. You have to focus on getting better. And you can ask your employer, does that mean you're letting me go? If they say yes, then that's a problem. They owe you severance and potentially human rights damages. More likely, that doesn't mean that. That means that when you're ready to come back to work, maybe it's in a week, maybe it's in a month, maybe it's in a year. At that point, they have to make efforts to take you back. And if they don't, you call me. But the fact that they say they're taking you off payroll, that doesn't mean anything. But ask the question. What does that mean? Does that mean I'm let go? Or does that mean I still have a right for my job when I'm ready to come back to work? And if you are let go, you want to call me right away. Again, employmentlawyer.ca. Okay. Best name of the day on YouTube, King. Awesome. Love that name. My employer denied my request for a religious exemption for the vaccine and I was suspended. Should I file that with the Human Rights Council or add that to my lawsuit for severance? No, it has to be part of your claim for severance. So don't do anything separate with the Human Rights Tribunal. It's not going to be successful. We need to include that as part of the claim for severance. So if you haven't done that, you need to call us right away so we can get started and do this properly. But no, doing it separately doesn't make sense and it's not going to be successful. Next question from YouTube. I am Anna Bully. If I'm put on an unpaid leave by my employer due to the vaccine and I found a new job, do I need to resign from my old job or wait to be terminated? Well, neither. You can choose to treat that as a termination at any time. If you've decided you're not going back to your old employer, the fact that they put you on a leave, that was a termination. So that's done already. It's happened. They've terminated your employment. You don't have to wait for it. You don't resign. You can't resign because they've already terminated you. So if you choose to treat that as a termination, we can move forward now and get you severance. So you don't do either. You simply treat that as a termination. Let's talk. Let's get the process going. Employmentlawyer.ca to connect with me off social media so we can get to work. 13 Demons on YouTube. Can someone get fired for having a conversation with a former employee? Someone can get fired for any reason, right? It's a question of severance. You can be let go because you drive a red car and your employer likes blue cars. You can be let go for that, no problem. But you have to get paid severance. So can your employer fire you without severance for talking to a former employee? No, absolutely not. They'll have to pay you severance, and that, depending on your length of employment and other factors, that could be as much as 2 years' pay. So if you have got your full severance, okay. If not, then that's a wrongful dismissal. And for you 13 Demons and anyone else, again, a reminder, if you want to find out now how much severance you are owed, it's probably a lot more than you realize. Just go to pocketemploymentlawyer.ca. Again, pocketemploymentlawyer.ca. You see that address below there? And use our severance calculator tool. You can find out in seconds, free, anonymously, how much you're owed. The Dreamer on Facebook or on YouTube. For a written or verbal warning to be valid, does the employer have to give it to you in writing, or is it good enough for them to say that you have been written up but not show it to you? Well, it's ineffective unless they give you something and you signed, acknowledge that you've received it. If they simply say it, then that's their loss, because it's going to be very difficult for them to rely on it. So let them do that, okay? That's kind of dumb for them to do that, but if they want to do something dumb, don't correct them. Let's see. Tracy Walker on Facebook. I resigned my job of 33 years. I had no other option. They kept adding duties of another employee, and that employee disrespected me in a meeting with 2 partners. Would this fall under constructive dismissal? I left my job in February and still have not yet received my pay, vacation, or ROE. So, yeah, I mean, if you can show what happened there, I mean, obviously your employer is not just going to admit what happened, but if you can show that they were changing your job or that you were treated inappropriately, absolutely that's a constructive dismissal, 100%. And after 33 years, you could be owed easily 2 years' pay. 24 months. That's a lot of severance that you're owed. So we should speak right away, and also, of course, about the issue of the vacation pay and the ROE. But I wouldn't wait on this, okay? My concern here always is to prove what happened. But let's talk about that as soon as possible. Employmentlawyer.ca. From Jordan on Facebook. When short of employees, can a potential employee draw up their own contract with the employer? And on average, how much would a contract cost to get drawn up? Can you do that? Sure. Will your employer look at it? I have no idea. It's up to your employer. Now, in terms of the cost, I mean, it depends. If you're a machine operator, that's very different than if you're an IT executive. So I would need to know more about your job. I need to know about the compensation, the terms, the bonuses plan, stock options, car allowances. So I can't say without knowing more about the job. Okay. So I think I'm caught up here. I see some more union questions. I'm not going to answer that only because the answer always is talk to the union. And if the union won't help you, there's not much that you can do. You can file a complaint against the union with the labor board, but the chances of that succeeding is very, very small. Again, thank you very much for joining us. Sorry about that technical issue we had earlier. Hopefully it won't happen again. If I didn't get to your question, no problem. Employmentlawyer.ca to find out more about your rights, to contact me, to send me an email, to call me. Check it out anytime you want, employmentlawyer.ca. I will be back next week, but don't wait until then. Let's connect before then. My name again is Lior Samfiru. I'm the employment lawyer, one of the founding partners of Samfiru, Tumarkin, LLP. I'll be back next week. Let's connect in the meantime. Have a great day, great rest of the week. Take care of yourselves, and we'll talk soon.